Hi, everyone. It's Hunter Lott, your HR problem solver on demand. And this is take 5 from our series. This is interesting. I had an attorney explain to me that freedom of speech was about your relationship with the government, not your relationship with the boss. So this headline came across my desk. Montana, employee free speech protected. Effective October 1st, employees in Montana cannot be fired for engaging in legal expressions of free speech, including on social media, unless the expressions violate employer's policy or a contract. And so I deep dive a little bit, and this was the sponsor of the bill in Montana. It said what people say on social media is irrelevant to their place of business, and as long as it doesn't reference anything to do with the workplace. Then went on to say, hey, here's some examples. This piggybacks on legislation we see in a lot of states where it is unlawful to go after usernames and passwords of social media as a privacy issue. I used my favorite AI, Claude, and I said, hey, what's going on with this? And Claude came back. 5 states have comprehensive laws now about freedom of speech expression with private employers. 4 states have more limited. Several states, as you can see, are looking at this. I noticed a lot of them deal with political speech in a time that we're leading into the 2024 election. I think we'll see more and more of this, but most of them contain carve-outs allowing employers to prohibit activities of speech that significantly disrupt the workplace. You can think of harassment, retaliation, some discrimination of some kind, but certainly something to watch. Montana also went on to ban TikTok. This should be interesting. I'm not sure how they're going to pull that off. And I bet they're going to be legal challenges. That goes into effect on 2024. We've seen on a federal level, NLRB, I don't know if you call it tighten or loosen the definition of conduct policies. Those of you that watch me know how big I am on behavior. It affects our ability to run our business, your ability to do your job. This is kind of, we've been here before. We had NLRB in the past go after these conduct policies. They gave us some examples at that time, no new examples with this one. So we'll have to wait and see kind of where the case law goes with this. Certainly it restricts activity on speech. Employers can no longer keep wages a secret. And that's been around a long time. They've started to enforce that about 10, 15 years ago. Rules requiring respect and professionalism are generally lawful. So that's a good sign that we can still go after behavior. Confidential trade secrets, non-solicitation, even if they were, the FTC were to eliminate no competes, we could still deal with that. Anything that would have a chilling effect on union activity, what's called Section 7 rights. And I love Claude ended by saying, hey, employers can reduce the risk by having an attorney review your policies. So keep an eye out on the behavior standards, some of these challenges that are popping up individual states and federally. I will certainly do the same and keep employers advised as to what's happening. It's going to be an interesting year in 2024. Thanks for watching. We'll see you next time on Take 5. Check us out at hunterlott.com. Again, we've archived the Take 5s. I'm getting a lot of positive feedback from people that watch, and I do appreciate that. We've got other various resources that we're constantly expanding the website, so please check us out at hunterlott.com. We'll see you next time.